Here you go.
So we can get started here. Thank you everyone for coming to the last day of the 12th annual Aboriginal Law Speaker Series. It's been a great week. We've had amazing speakers. Thank you everyone for coming out. I see some people here. I've been here every day, which is awesome. Appreciate it. My name is RJ Simpson. I'm the third-year law student and the president of ALSA. Each year ALSA puts on this speaker series. We choose a topic and we bring in experts from around the country and internationally. This year's topic is Aboriginals and the criminal justice system. I'd like to start off by acknowledging that we're on Treaty 6 land, and I'd like to welcome all Treaty 6 members. We have a professor here, Kathy Bell, who always likes to remind us also that regardless if you're a First Nation or if you are represented by the Government of Canada, we're all actually treaty people, we're all parties to the treaty. I'd like to acknowledge one of our speakers who's been in attendance for the entire week. We're honored to have him, the former Chief Justice of the Supreme Court of the Navajo Nation, Robert Yazzie. He spoke yesterday, packed the House. I'd also like to thank any other elders who have made time to attend. Finally, I'd like to thank the Faculty of Law for providing this space for us. And I'd like to thank the ADCO Group and the Alberta Law Foundation for their generous support, financial support, for making this all possible. So the presentation will be for about 45 minutes, and then we'll leave about 5-10 minutes for questions. Sometimes these, well, this one won't go long. We have to take off right after. So today's speaker, we're honored to have him, Howard Sapers. He's the Correctional Investigator of Canada. He's the Corrections Watchdog. This is he's been serving the position since 2004. He's been appointed 3 times. His office's primary functions are to investigate and bring resolution to offender complaints, review and make recommendations on the correctional services policies and procedures, and to ensure that systemic areas of concern are identified and appropriately addressed. He has an extensive list of credentials and awards and recognitions, so I'm only going to go through a few. He's twice been elected as MLA for Edmonton and Glenora from, I think, 90... Doesn't matter. Oh, doesn't matter. In his second term, he served as the House Leader and leader of the official opposition. He's been the Director of the Crime Prevention Investment Fund at the National Crime Prevention Centre, Executive Director of the John Howard Society of Alberta, President of the Alberta and the Canadian Criminal Justice Association, Vice Chair of the City of Edmonton Safer Cities Advisory Committee, Vice Chair of the Prairie Region Rural Board of Canada, and he received national recognition for his work. To name a couple, he's been recognized as a champion of mental health by the Canadian Alliance on Mental Illness and Mental Health, and he's received the President's Commendation from the Canadian Psychiatric Association. He's taught criminology and correctional law at Grant MacEwan University, and he's an adjunct professor in the School of Criminology at Simon Fraser University. I could go on and on, but I'll just let him talk. Howard Sapers.
Thank you. Thanks very much for that. I truly would like to acknowledge the traditional stewards of the state party, and thank you all very much for the welcome. I am very, very happy to be in Edmonton. It's still home in a lot of ways for me. And I'm going to say at the outset that I'm going to avoid eye contact with this half of the room because there's people that I know most of my adult life and some that I've known their entire lives sitting over there, and we'll just have private conversations if I glance over, which I'm doing all the time. Nice, thanks so much for coming. This is a very, very important speaker series. And I know that this is the end of the week, and it's been an interesting and engaging week. I also know that it's Friday. I also know that first-year law students typically don't have any meetings on campus on Friday. And so for those of you who made the commitment to be here, not just today, but all week, thank you. And to the organizers, outstanding job, tremendous faculty that was put together. I only regret that I wasn't able to participate in more of this series. It's so nice to see that these issues are being discussed and here and in law schools and engaging faculty and students and communities. It's a very good thing that you're doing. I'm not going to spend a lot of time today talking about the Office of the Correctional Investigator. I could go on forever talking about the office. If any of you are interested in finding out more about the work of the Office of the Correctional Investigator, our mandate, the kinds of reports that we do, everything we do is on our website. And it's www.oci-bec.gc.ca. If any of you missed that, just Google Correctional Investigator and it'll take you there. And in particular, one of the reports that I'd like to draw your attention to, I'm going to be talking about it today. It's called Spirit Matter. We'll get into that in a minute. It is available on our website, and I think you'll find it of interest. My remarks today are focused on the specific challenges of Aboriginal men and women serving in federal sentence, right? So a sentence of more than 2 years sentenced to federal penitentiary. It was actually 1 year ago today that Spirit Matters, Aboriginal People and the Correctional and Conditional Release Act was tabled in Parliament. And that's very significant because it's only the second time in the history of the Office of the Correctional Investigator, over that 1971, that a special report was tabled in Parliament. I think that reflects the reality that the issues we're going to be talking about are both urgent and alarming. This afternoon, I want to provide some commentary on the social, cultural, and historical circumstances that contribute to disproportionate rates of Aboriginal incarceration in Canada. I'll conclude my presentation today with some thoughts about what could and should be done to narrow the widening gap in correctional outcomes and results for federally sentenced Aboriginal people. Let me say at this point that I appreciate that these disproportionate rates of overrepresentation of Aboriginal Canadians fall largely outside of the Correctional Service of Canada's mandated jurisdiction. Certainly, there are areas of responsibility. Reducing the rate at which Aboriginal people come into conflict with the law requires a whole of government approach. This would, of course, include things like education, employment, housing, healthcare. With that said, there are, though, some things that the correctional system must do to address disparities in outcomes for Aboriginal offenders sentenced to their care and custody. It's on these matters that I will focus my remarks. The representation of Aboriginal people entangled in Canada's criminal justice system is not new. The social, cultural, historic, economic factors that give rise to Aboriginal incarceration rates that are several times higher than national rates have been extensively documented. As the Royal Commission on Aboriginal People concluded, high rates of Aboriginal incarceration speak to a people's loss of culture, identity, and spirit. On occasion, these matters have given rise to intervention by Canada's highest courts. In the 2012 appeal ruling, for example, the Supreme Court of Canada reaffirmed its earlier landmark decision in May. Let me quote the court. The courts must take judicial notice of such matters as the history of colonialism, displacement, and residential schools, and how that history continues to translate into lower educational attainment, lower incomes, higher unemployment, higher rates of substance abuse and suicide, and of course, higher levels of incarceration for Aboriginal peoples. Quote. The point of taking judicial notice of such matters is to acknowledge that remedial measures are necessary to mitigate the underlying factors and circumstances that lead to disproportionate rates of Aboriginal offending. The courts have made it clear that value factors must be considered whenever the liberty interests of an Aboriginal person are at stake. In corrections, this means the Correctional Service of Canada, or CSC, must consider the social history of an Aboriginal offender in security classification, penitentiary placement, institutional transfer, and segregation decisions. The Supreme Court references in Gladue and Peely recognize a history of disadvantage follows Aboriginal men and women in prison. Beyond sentencing, a number of value factors are to be considered by decision makers when the interests of an Aboriginal offender is involved. For example, they're to consider the effects of residential school system, the experience in child welfare or adoption systems, the effects of dislocation and dispossession, family or community history of suicide, substance abuse, and victimization, loss of or struggle with cultural and spiritual identity, the level or lack of formal education, poverty or living conditions, and exposure to and membership in Aboriginal street gangs. In correctional language, this Aboriginal social history roughly translates into high risk, high need, and low reintegration potential. The disparities between Aboriginal and non-Aboriginal offenders are distressing because of this translation. For example, Aboriginal people under federal sentence tend to be younger, less educated, and more likely to present a history of substance abuse, addictions, and mental health concerns. Aboriginal offenders are classified as higher risk and higher need in categories such as employment, community integration, substance use, and family support. Aboriginal offenders are more likely to be classified as maximum security, spend more time in segregation, and serve more of their sentence behind bars prior to first release. Aboriginal offenders are far more likely to be detained to warrant expiry or return to prison with or without a new criminal charge than non-Aboriginal offenders. Aboriginal persons are disproportionately involved in prison use of force interventions and prison self-injury incidents. These realities, unfortunately, define Aboriginal corrections in Canada, and they defy easy solutions. What is especially troubling is that the gap in results and outcomes for Aboriginal offenders is widening on the most significant indicators of correctional performance. At the time of the Spirit Matters investigation, parole grant rates, security classification, segregation placements, work releases, disciplinary charges, community employment were all trending in the wrong direction for federally sentenced Aboriginal people. Now, let me pause at this point and say the news is not all bad. For example, there is some positive progress being reported in the areas of escorted and unescorted temporary absences for Aboriginal offenders so that they can participate in cultural community activities and to maintain community contact. As well, there are higher program enrollment and completion rates today than there were a year ago today for Aboriginals involved in culturally appropriate programming. The CSC is creating more Aboriginal-specific positions, such as Aboriginal community development programs and community liaison officers. And the number of Aboriginal offenders returning to their home communities is finally, slowly beginning to increase. However, these gains are more than offset by the ever-widening gaps in areas such as overrides to higher security, increases in day and full parole hearing waivers, and the number of parole suspensions and revocations. Indeed, the majority of First Nation, Métis, and Inuit offenders gain release today from a federal prison by statute, on statutory release, at the 2/3 points of their sentence, not through a discretionary release of parole. The CSC recently released results of a research study looking at a sample of Aboriginal offenders enrolled in the Aboriginal Offender Substance Abuse Program. Based on the self-reported data for 316 Aboriginal men, the study paints a distressing picture. Half of the sample indicated that they had been in the care of the child welfare system. 71% had spent time in foster care and nearly 40% in the home. Almost 2/3, 61%, had family members who had spent time in prison. 3/4 reported a family history of involvement with the residential school system. 18% themselves said they were residential school survivors. Almost all, 96%, indicated that substance abuse was related to the current offense, and 85% were in fact intoxicated at the time of their index offense. And 88% reported they had a family member with an alcohol or drug addiction. Today, nearly a quarter of the federal incarcerated population is Aboriginal. In 2000, Aboriginal inmates accounted for 17%. My office estimates that Aboriginal adults are now incarcerated at a rate that is almost 10 times higher than the national average. And these rates are increasing. Since 2005, there has been a 43% increase in the Aboriginal inmate population, compared to just a 5.6% increase for non-Aboriginal inmates. There are now over 3,500 Aboriginal offenders inside our federal penitentiaries. The statistics aren't any better at the provincial and territorial levels. In 2010-11, 27% of adults in provincial and territorial custody were Aboriginal. It's about 6 times higher than the provincial and territorial average. 26% of all admissions to youth custody across Canada were Aboriginal youth. The numbers are even more alarming again for women. By the end of 2011, 41% of all women incarcerated in Canada were of Aboriginal heritage. At the federal level, 1 in 3 federally incarcerated women is Aboriginal. In fact, Aboriginal women are the fastest growing subpopulation in federal corrections. The number of Aboriginal women in federal custody has doubled in the last 10 years. Aboriginal women account for 59% of all federally sentenced women here in the Prairie region, leading the country. Women are also more likely to come to prison with histories of self-harm, physical and psychological trauma, and sexual abuse. This is the context within which my special report to Parliament on Aboriginal corrections was released. Spirit Matters represents my office's assessment of how Aboriginal-specific provisions of the Corrections and Conditional Release Act, the law that governs federal corrections, have been applied since they came into force in 1992. In particular, the report examines the use of sections 81 and 84 of the law. Section 81 allows for the minister to enter into agreements with Aboriginal communities to transfer care and custody of Aboriginal offenders who would otherwise be held in a CSC facility. Section 84 provides for Aboriginal community involvement in the release planning for an Aboriginal offender returning to his or her community. The legislation also provides for a National Aboriginal Advisory Committee, and it makes it clear that Aboriginal elders and Aboriginal spirituality have the same status as other religions and other religious leaders. When enacted in 1992 by the federal government, Aboriginal-specific provisions of the CCRA were part of a series of remedial measures designed to stem the tide of the overrepresentation of Aboriginal people in corrections. Other reforms, in part driven by the Royal Commission on Aboriginal Peoples, included the introduction of new sentencing principles in 1996 and culminated in the aforementioned landmark Supreme Court of Canada decision in 1999. These sections of the law govern the correctional practice and treatment of Aboriginal offenders under federal sentence. They do not imply or give rise to preferential treatment. Aboriginal-specific provisions of correctional law give expression to the notion that in order for our system to be fair, individual differences must be acknowledged. Equality does not mean treating everyone the same. It means recognizing disadvantage and disparities in both opportunity and outcome and trying to remediate. The purpose of Spirit Matters was to investigate whether the Correctional Service is doing all it can and should to make sure the will of Parliament is respected in regard to appropriate consequences and treatment for Aboriginal offenders. So, what did we find in the investigation 20 years after the CCRA was enacted by Parliament? In short, we found some serious and troubling gaps between the law and practice. We found limited use of sections 81 and 84 to transfer care and custody services and programs to Aboriginal communities. Only 4 Section 81 agreements have been concluded with Aboriginal communities since 1992. Only 68 bed spaces, 68 beds have been created in those 4 agreements. That represents meeting the need of just 2% of today's federally censused Aboriginal population. There are no Section 81 beds available in British Columbia, Ontario, Atlantic Canada, or New York. Although one existing agreement has been expanded, no new Section 81 agreements have been signed since 2001, despite the 40% increase in Aboriginal incarceration. 3 of the 4 Section 81 facilities are on reserve land, yet most Aboriginal offenders are released to urban settings. There were no Section 81 beds for Aboriginal women until September of 2011, when the counseling service expanded its agreement here in Edmonton and opened up the Buffalo Stage section. We also found disparities between the CSC healing lodges and Section 81 facilities in the Aboriginal communities. For example, there are no permanent funding arrangements in place for those 4 Section 81 agreements. Section 81 facilities operate on substantially lower budgets than their CSC counterparts. Salary and benefit disparities are huge, and there are significant reporting, financial, and insurance and operational burdens placed on Section 81 operators. With respect to Section 84, we found implementation to be underutilized, overly complex, bureaucratic, unevenly applied, and not well understood within or outside of the Correctional Service of Canada. At the time of our report, out of a workforce of approximately 19,000 employees, Correctional Service of Canada had only 12 Aboriginal Community Development Officers to help facilitate Section 84 units. We found that the number of Section 84 releases, in fact, dropped by more than 50% between 2005 and 2011. As reported in Spirit Matters, fewer than 100 Aboriginal offenders benefited from Section 84 releases in 2010-11. Though these numbers are beginning to climb now that this option has finally been made available to Aboriginal offenders for their statutory releases. Other key findings of Spirit Matters. Number 1, stricter eligibility criteria effectively exclude most Aboriginal offenders from Section 81 consideration. Disproportionately, Aboriginal offenders are classified at higher security levels. Section 81 agreements require them to be classified as minimum security. So by policy, not by law, we exclude the majority of anyone who can benefit from security. There is a limited understanding of Aboriginal people, culture, and approaches to healing within federal corrections. Number 3, inadequate and uneven application of diverse social history considerations in correctional decision-making. Funding and contractual limitations impede the work of elders inside federal institutions, and there is an inadequate response to the urban realities and demographics of Aboriginal people. To address these findings, Spirit Matters made 10 recommendations. Amongst them, number 1, appoint a Deputy Commissioner for Aboriginal Corrections to ensure adequate focus and accountability. There is no senior leader who is solely responsible for Aboriginal corrections at the federal level. Negotiate permanent, realistic, and at-parity funding levels for existing and future healing lodges, and significantly increase the number of bed spaces where the need is to be demonstrated. Number 3, expand CSC staff training initiatives about Aboriginal people, history, culture, and spirituality, and include training in the application of collective principles. Resolve workload payment and standard of service issues faced by elders to ensure that they are equal partners as envisioned in the CCRA. And 5, reduce the red tape and accelerate the process for Section 84 releases. The Correctional Service of Canada's initial response to Spirit Matters was disappointing. All of the report's recommendations were either rejected or they were used to somehow endorse the status quo. In short, I concluded that the Correctional Service of Canada's response failed to meet the urgency, immediacy, or importance of the issues raised in the investigation. CSC's response to Spirit Matters was so disappointing that in my latest annual report, which was tabled in Parliament on November 26, 2013, I called upon the service to consult with its National Aboriginal Advisory Committee and update its response. I further recommended that the service publish an accountability report summarizing correctional outcomes, programs, and services for federally sentenced Aboriginal people that will be tabled annually in Parliament by the Minister of Public Safety. Faced with these new recommendations, the service is of the view that its Aboriginal Corrections Accountability Framework, I feel better knowing there's an Aboriginal Corrections Accountability Framework, is robust, I'm quoting now, and well integrated with its other public reporting requirements. I disagree. Simply put, in the interests of transparency and accountability, CSC should be required to report to Parliament and Canadians its progress in narrowing the gap in correctional results and outcomes for Aboriginal offenders. To that end, internal performance measures and mechanisms, including the CSC's Aboriginal Corrections Accountability Framework, should be publicly accessible documents. Canadians should not have to file access to information requests to see how their correctional system is faring in managing nearly 1/4 of its population. Regarding the call to appoint a Deputy Commissioner for Aboriginal Corrections, I acknowledge that more bureaucracy will not solve the problems at hand. At the same time, though, there must be a stronger, more coherent, and consistent leadership on these issues at CSC's senior management table. To my mind, that means appointing an individual solely and exclusively accountable for progress in reducing the gap in disparities and outcomes for federally sentenced Aboriginal people. The release.
No, it's just timed out.
The release of Spirit Matters attracted substantial media coverage. Most of the reporting was balanced, fair, was positive. Overall, I was quite pleased by the level of public interest and engagement. It suggests to me that Canadians are genuinely concerned about these issues and looking through all borders of government to better engage Canada's Aboriginal people. Of course, not all of the commentary has been positive or helpful. For example, I continue to encounter the argument that Aboriginal incarceration is a matter of choice or character, a kind of predisposition to commit crime. As one recent national editorial writer put it, quote, "If the number of Aboriginal prison inmates is growing, it's not because of racism, it's because they are committing crimes," end quote. By this way of thinking, the reason there are a disproportionate number of Aboriginal people in bars is because they break the law. The inference is that an Aboriginal offender, like any other sentenced criminal, gets what he or she deserves. I've also heard mention of the need for Aboriginal people to take more responsibility for their criminal actions. Others have expressed the view that only bad people go to jail. Again, the argument here is that more Aboriginal people are behind bars because they proportionately commit more crime. Such claims are simplistic, dismissive, and wrong. In the first place, they fail to take into account the prevailing economic, social, and demographic conditions that place certain groups at increased risk of early and recurring conflict with the law. Secondly, they ignore Canada's own history of race-based policies and rhetoric. The factors and circumstances and social histories which give rise to Aboriginal offending, failed government policies and programs like assimilation, institutionalization, poverty, intergenerational trauma, addiction, and people's lack of control over their own lives are either ignored in this analysis or they are dismissed as unimportant. The system itself is assumed to be fair, independent, and equal to all. The fact that outcomes for Aboriginal offenders are so poor and deteriorated over time is considered to be a result of a lack of individual enterprise and failure to take responsibility rather than evidence of systemic disadvantage. The argument ignores the broader context in which people come in conflict with the law of Canada. When interviewed or questioned about Spirit Matters, I'm often asked whether the correctional system discriminates against Aboriginal people, whether it's biased, prejudiced, or even racist in its design or its intent. Let me be clear. I found no evidence that anybody purposely designed CSC programs, policies, and practices to be discriminatory. Yet, in fact, these programs, policies, and practices produce differential outcomes for Aboriginal offenders. Systemic discrimination, of course, is rarely premeditated or intentional. This happens when large systems, while trying to be neutral, ignore important differences that result in an identified group being harmed by insensitive administrative policy and practice. In its 2001 speech from the throne, the government of Canada committed to, and I quote, significantly reduce the percentage of Aboriginal people entering the criminal justice system so that within a generation it is no higher than the Canadian average, end quote. 13 years later, we are further away from that goal. The Correctional Service has had 20 years to develop and implement agreements with Aboriginal communities to facilitate the community transfer of Aboriginal offenders who would otherwise be held in penitentiary. It is my view that considering the rising levels of need, the lack of significant progress on this file is indefensible. We know how to do better, and we must. I am much more encouraged by the response at the community level. Since the release of Spirit Matters, I have met with a number of provincial, territorial, and national federations and councils representing First Nation, Métis, and Inuit peoples right across Canada. Within local and national communities, there is both engagement and concern in how to best address disproportionate rates of crime, victimization, and incarceration. I see indications that there is renewed interest amongst Aboriginal communities to use Aboriginal-specific provisions of law to better support safe and timely release. The fact that nearly 1/4 of our prisons are occupied by Aboriginal people, and that most Aboriginal offenders are released from prison by statute, to Ruth's point, are just two of the indicators of how far the yardsticks continue to be moved. I understand that the problems that we're talking about concerning the relations between Canada and its Indigenous peoples are literally centuries in the making. There is no erasing the past. We will continue to have to face the legacy of failed public policies, including colonialism, displacement, and of course, residential schools. Criminal justice fixes are certainly required, but so are health, housing, education, and employment fixes. The path of healing and reconciliation reaches well beyond corrections and the mandate of the prison ombudsman. I have no doubt that the solutions will be rooted in fairness and accountability, transparency, and respect. Spirit Matters concluded that stronger leadership and improved implementation of mandated Aboriginal initiatives are required to address the growing problem of Aboriginal representation in Canada's prisons. The problems are well known and potential solutions have been identified. It's time to simply get on with it. I want to thank the organizers again. Thank you for inviting me. I wish you all success in your work, studies, and I believe we have some time for questions.
I used to work in practice for about 12 years. One question is, like, during your research and trafficking and doing this study, how often do you come across with correctional candidates and using the Salvation Army as alternative housing measures for Aboriginal offenders? There wasn't no territories where they used to use the Salvation Army. They just lost the correctional license a few years ago because of lack of following correctional procedures and like that. And Salvation Army there basically told me that offenders respond to Aboriginal offenders can join Christianity, which is just something that, you know, take the hell out of me off. But it also, all my offenders and clients are saying they're programmed in. They've gone through Gold Eagle program, they've gone through my Dirty Warrior program, all these things. There's a program they just want to go home.
Yeah. A whole bunch of really good questions there. So number one, the Salvation Army has a long history in corrections in Canada. Salvation Army provided first parole supervision, are able to do that in Canada. So there's been this mixed economy of the Salvation Army and other NGOs and charitable organizations involved in community corrections. And I don't see that coming to an end. Salvation Army has one particular approach, Howard Society has an approach, Humane Association, Prize Society, Women's Society, and they all have varying kinds of contractual relationships with the correctional service across the country. So I don't see that ending, and nor would I want to see that. I think that, well, there's some bias in my comments. If you listen to my introduction, I used to Howard Society here member, so obviously I have a belief in that kind of involvement. That said, I don't think that I don't think that participation in a program should be based on your willingness to embrace one particular spiritual ideology. And in fact, I think sometimes it can serve as cross purposes, and there's lots of examples of research about that. In terms of being programmed out, though, I live in a really special little world, you know. My day job is to make prisons the best they can be. So think about that for a minute.
And if you were to do KP, I don't think that can really.
We actually have developed and we deliver some excellent correctional information in this country, and they've been adopted around the world. I actually believe that good correctional programming delivered at the right time by competent people in the right circumstances can make a really profound difference in people's lives. I also think that incarceration should be used sparingly as a last resort because it is inherently destructive. So I have to balance those two thoughts in my head. If you're going to be there, the goal has to be to get out better. And part of the way we do that is with correctional program. But I think
Sir, you don't seem to mention in your remarks this phenomenon called prison industrial economy. Like in the United States, it's a business center now, and they basically get people as slaves. They can make them believe that they want. They do very specifically work. They make parts correctly, and more name tags that have to be and stuff like that. And that's a brand new idea that's making its way into Canada. So, you know, wouldn't you, in terms of your analysis about where this whole ship is going, say, well, what are we going to do about that? Is that something that sort of, gets to the whole economic base of the justice system in the first place? Like you're hiring judges, you're hiring guards, you hire yourself. You know, there's a whole industry there, and if you don't have merchandise, you don't have an industry. So you got to keep producing this merchandise, which, for the most part, the Native people over the years have been managed. So thank you to the Native people. Once again, we took your land, now we're taking you again to build this economy. And there's something really fundamentally wrong about that I think perhaps it should be articulated.
Yeah. The reality of overrepresentation is dramatic, and obviously that spills off into discussions about economic disadvantage and exploitation, both in terms of labor and resource. And I think they're important discussions. The bread and butter of my mandate is to respond to and resolve offender complaints and to provide comment on systemic issues as they affect the mandate of the Correctional Service of Canada. That is a much broader discussion, which you suggest needs to be had, and I would agree with you. I will note that in Canada we have only the most tentative experiments into the kinds of prison privatization that we've seen south of the border, Australia, and the United Kingdom. In spite of this history of mixed economy, which I mentioned earlier, we've always had public-private partnerships in criminal justice systems. Prison industry and vocational training and preparation is an important pre-release activity. Prison industries provide employment, skill development, and even cash to the incarcerated population. obviously we have to respect that there's a line between providing support to individuals and exploiting them for other purposes. So we don't have the kind of private enterprise in our prisons that you see in some American, particularly prisons at the state level, where, in essence, subsidized labor is being provided to industry. We don't do it that way here. It's a matter of scale, perhaps. Canada's incarceration rate is in the 130 per 100,000 range. U.S. incarceration rates in the 750 per 100,000 range. It's a huge difference. In the United States, though, before we demonize them too much, every state in the Union is currently engaged in either criminal law reform, correctional law reform, deinstitutionalization, closing of penitentiaries, or taking some action to lower that incarceration rate. Compare that to what's happened in Canada in the last 10 years. So they seem to have learned some lessons. And I encourage the kind of debate that you raise.
It's very discouraging from a defense point of view to hear of the impact of life report on the actual incarceration timeline and this. So I'm just wondering if there have been any studies that have actually compared the actual incarceration time of offenders with similar offences who have or have not been subject to the vital report. And if you've got any advice to defence counsel in terms of requesting or not, or advocating for vital reports, given that reality.
Yeah, I have not seen that research that specifically looks at those offenders where vital reports were ordered and those where there's not. I have not seen that research. I don't know whether it exists or not. One of the previous speakers in the series, Jonathan Rubin, may be a better source of information on that. I can tell you that I think there's a more fundamental issue, and that is even with a really well done value analysis, the recipients of that report don't often know what to do with it. And so the degree of training that has to go into the system so that bench and crown and defense and corrections officials know what that means and how to apply it and what kind of filters to apply. There's an immense deficit there. And so there's been some effort on the defense part to make sure that they're sensitive and there is training and awareness about value, but it has to also take place deep within the system before it's going to make any significant difference. This must be.
One other question.
Oh,
is there any attempt right now in corrections to train people in value? Are there strides being made?
Yes, and you know, I always focus on bad stuff. It's like I talk about all the negative stuff. Corrections has made significant and sincere attempts in terms of training and orientation, and so it's getting better. But it's such a long way to go. But at least there's acknowledgement that the deficit exists and something has to be done.
There's no more questions?
What's there factoring in things like pretrial custody, things like that? There's a report that just came out both provincially and federally that's showing that there's a rise in pretrial custody, people being demanded for crimes that they have not yet been found guilty for. So we need this young gentleman, get drunk in his early on right at or about to get arrested. Chance they're all being remanded and everything. And he'll probably he gives a RRR and he's saying see you in 2 weeks.
6 out of 10, roughly speaking, 6 out of 10 men and women in a provincial territorial custody today are remanded in trial. 6 out of 10. That's switched. That's turned. So if you think about that, 60% of our incarcerated men and women today at the provincial and territorial level are in custody and they haven't been convicted of anything. And an overwhelming majority of those people come from very marginalized and vulnerable groups in society. And I continue to hear courts say things like, well, this is the best possible place for you. You will be safe. You can see a doctor. You'll get food. You'll be out of the cold. I hear the defense counsel contact my office all the time and say, we're making sentencing submissions. Where's the best prisoners? Should we ask for more than 2 years so they get those gold-plated federal programs? These things drive me crazy. There's nothing good about being in jail or prison. And as a society, we should really be questioning what it means when we say this is the best place for you. You're sick and you're cold and you're hungry and you're homeless, and our response is jail. So, you know, I'm well beyond my mandate, but when you talk about provincial territorial remand rates, how do you address that without talking about these more fundamental issues?
I think we'll wrap it up. We got to get our speakers to the airport. So thank you guys all for coming out. We appreciate your support all weekend. Thank you again. Yeah.